on Civil Procedure. Okay, diretso. Yung 2020 Rules on Civil Procedure were promulgated by the Supreme Court precisely, my friends, because of the Supreme Court's rulemaking power or the power of promulgation, actually. So let me begin, my friends, no? So if you will read the amendments, actually, if you will study it carefully, you will realize that there are how many areas here? Only 9 areas to consider, okay? What are these? Amendments under the rules on pleadings. Pagkasama-samahin ko na. Rule 6, 7, 8, 10, 11, and 13. The number 2, amendments, no? Under Rule 10 on amendments. Okay? Important changes introduced to the rules on amendment under Rule 10. What else? Amendments under the rules on summons, Rule 14. Okay? What else? Amendments under Rule 15 on motions. Amendments, of course, introduced to Rule 18, pre-trial. Dito, marami po. Ayan. And of course, Rule 30, trial, my friends. Finally, there are amendments also that should be discussed under Rule 33, my friends. Okay, under Rule 33, demurrer to evidence, and of course, judgment on the pleadings under Rule 34 po yan, Rule 34. Okay, and of course, summary judgment, Rule 35. So let us enjoy our journey towards the rules on civil procedure. Notable changes in amendment under pleadings. If you talk about the rule on verification, di ba? Yung verification po, yung attestations niya, expanded na. Bakit? Okay? I'll start, my friends, no? By first, ito. Di ba yung sa verification, who must sign the verification? General rule, the party must sign the verification. Certification is from shopping, the party must sign. The certification is from shopping. That is the rule. Okay? Pero paano if the party is an individual? Okay, and he executed a special power of attorney, SPA, authorizing another individual to sign the verification is not allowed. Di ba? What if the...
Of course, in cases filed against you, you don't merely avoid conviction. Of course, there are some things that you would also have to consider. First, the time. Second is the investment. Third is the opportunity. Fourth is your peace of mind. And fifth is your personal wealth. So out of the 100 targeted accounts, hackers were able to reset 45 user accounts' passwords. Now, these hackers
be very fast in saying, yes, I want to go fishing with you, because this person might be talking about a different kind of fishing, a fishing that will lead to a criminal offense and probably put you in prison.
Does not fall under the Data Privacy Act if it is an information pertaining to an entity that is not a natural person. Consent must be something that is mechanical and tangible. It must be proven. That is consent that is required under the Data Privacy Act. You have to prove that you have obtained the consent from a data subject. So who may wish to have some questions, probably they can send their questions to the Villasis Law Center and we'll try to answer them.
Three things, no? We were reminded by the National Privacy Commission that the cardinal rule, if you talk about processing of data information, is that do not collect if you cannot protect. The primary impact of the Data Privacy Act, my friends, are the 8 rights provided by law. Very important. There are 8 rights here. You talk about the right to be informed, the right to access, the right to erasure or blocking, the right to object, the right to rectify. You talk about data portability, the right to file a complaint, and of course, the right to damages. Data is more valuable than money, because if someone takes your money, that's all they have, okay? But if you let someone take your data, oh my God, eventually they will take your money too.
So does the DPA only cover personal information per se, or does it also cover information about companies, testing results, and
Hi, sir. Good
Hi.
evening. Sir, just a question about the DPO officer. Is there such a thing as a void or not valid DPO officer appointment, wherein even though the NPC has properly recognized his appointment?
We will be having our second quiz.
Just kindly, enter the link in the chat box, okay? So we can get started. So I think a little bit of an icebreaker is in order. Can we bring out the wheel?
Yes, we will do again a raffle. Congratulations! Ronaldin A. Urban.
Who must sign the verification? General rule, the party must sign the verification. Certification is from shopping, the party must sign. The certification is from shopping. That is the rule. Okay? Who must sign the verification? General rule, the party must sign the verification. Certification is from shopping, the party must sign. The certification is from shopping. That is the rule. Okay?
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual class and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is a business law and business transactions law professor at the University of the East Manila and the Polytechnic University of the Philippines in Santa Mesa, Manila. He was a former CPA licensure exam reviewer at the Pamantasan ng Lungsod ng Manila or PLN, and a former special science teacher at the Philippine Science High School main campus. He was a former tax advisory associate at Panambayan and Arelo, before joining the Public Attorney's Office as one of its lawyers. Ladies and gentlemen, let us all welcome Attorney Dabumar Burgos.
Good day, everyone. I am Professor Dabimar Burgos, and welcome to this free online lecture brought to you by the Virtual Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like the VLC Facebook page and share this FB Live session. Host a watch party via FB and tag your friends now, and together learn at the comfort of your homes. Before we start, please comment VLC if you can hear me clearly, if you can hear my voice clearly. Okay. So again, good afternoon to everyone. I was asked to discuss with you the salient features of obligations and contracts. Just an introduction. I am Professor Dabimar Burgos. I'm a former tax advisory associate of Punong Bayan and Araulio. Okay. Because of limited time, I will be discussing just parts of the obligations and contracts. So for obligations, I will focus on definition and sources, the kinds of obligations, extinguishment of obligations. For contracts, okay, we'll focus on basic concepts and characteristics and the forms of contracts. Okay? So makinig lang kayo sa akin at sabayan ninyo ako sa pag-aaral natin ng obligations and contracts. Okay? So we start with the definition of obligation under 1156. The Civil Code defines obligation as the juridical necessity to give, to do, or not to do. Okay? I'd like to emphasize the words juridical necessity. Okay? Bakit? Juridical necessity in the definition means that in case of non-compliance, the courts of justice may be called upon to enforce fulfillment of the obligation, or in some cases, the economic value that it represents. Meaning to say, na kapag hindi pinerform nung debtor yung obligation, okay, the courts of justice may be called upon to enforce the fulfillment of the obligation. The obligation defined under 1156 is what we call civil obligations, because there are other obligations, just like a natural obligation and a purely moral obligation. Okay, when we say natural obligation, this is an obligation that is based on equity and natural law. And as to purely moral obligation, it is based on equity and natural law, and sometimes based merely on conscience. Okay, in natural obligation, there is a juridical tie, but the juridical tie was rendered ineffective. While in purely moral obligation, there is no juridical tie at all. And both natural obligation and purely moral obligation, they are not enforceable in courts of justice. So unlike a civil obligation under 1156 that is enforceable in courts of justice in case of non-compliance, for natural obligation and purely moral obligation, hindi po sila po pwedeng ipa-enforce in courts of justice. Okay? Example of voluntary obligation and purely moral obligation. When we say natural obligation, the voluntary payment of monetary interest when there is no express stipulation in writing for its payment. So that is an example of a natural obligation. While purely moral obligation, the obligation of the employer to give free legal assistance to his employees. Okay, this is based merely on conscience or based merely on equity or morality. There is no juridical tie and it is not enforceable in courts of justice. Okay. However, take note that in case of natural obligation, if the debtor performs voluntarily the obligation, our courts can order the retention of what has been delivered. Ibig sabihin, as an element of natural obligation, kapag pinerform ng debtor yung obligation voluntarily po, pwede pong i-recognize ng ating korte yung effect ng performance. But take note, according to the Supreme Court, there must be a voluntary fulfillment on the part of the debtor. Ibig sabihin, the debtor must have the knowledge that he has no obligation to perform, pero pinerform pa rin niya yung obligation. Because if the debtor performed by mistake the obligation, he may recover whatever he has delivered to the creditor based on solution indemnity. So take note, I repeat, in case of natural obligation, if the debtor voluntarily performs the obligation, pwede pong bigyan ng effect yung performance na yan. I-recognize yan ng ating courts. Okay? Now, we go to the sources of obligation. Under 1157, we have 5 sources of obligation. We have law, contracts, quasi-contracts, delicts, and quasi-delict. Tingnan natin isa-isa and tingnan natin yung rules bawat source of obligation. Let's start with law. Okay? When we say law, these are the obligations imposed by the law itself, legal obligations. Ang rule dito is that they are not presumed because they are considered a burden upon the obligor or upon the debtor. And to be demandable, there must be a clear provision of law that sets forth the obligation. Kapag wala pong batas na nagsasabi, then hindi mo po pwedeng i-perform yung obligation or hindi mo po pwedeng i-demand yung performance ng obligation. Example ng obligations arising from law, we have the obligation to pay taxes and the obligation of the spouses to support each other under the family code. So these are examples of obligation arising from law. Okay? Other examples to illustrate this principle that in case na wala pong a clear provision of law, hindi mo po pwedeng i-demand yung performance ng obligation. In this case, decided by the Court of Tax Appeals in the case of Oñate versus CIR. Ang sabi ng CTA dito, the BIR has no legal duty to pay legal interest on taxes erroneously withheld in the absence of statutory provision clearly directing the payment of interest by the government. So that is an example of an obligation arising from law na kapag daw walang statutory provision na nagsasabi for the payment of legal interest, then the BIR has no legal duty to pay legal interest on taxes erroneously withheld. Okay? Another example in the case of De La Cruz versus Northern Heretical Enterprises, gaya nung nabanggit ko kanina, the employer has no obligation to give free legal assistance to his employees. However, in the case of Pelayo versus Lauron, the Supreme Court said that as part of the obligation of the spouses to support each other, okay, in times of illness, when either of them by reason of illness should be in need of medical assistance, the other is under the unavoidable obligation to furnish the necessary services of a physician in order that health may be restored and he or she may be freed from the sickness by which life is jeopardized. Because sabi ng Korte Suprema dito, the spouses are mutually bound to support each other. Okay? Let's go to the second source of obligation from contracts. And the Civil Code defines contracts as the meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Okay? But take note that for a contract to be a valid source of obligation, the contract must not be contrary to law, morals, good customs, and public policy. Because if the contract is contrary to law, morality, etc., then the contract will not be considered as a source of obligation because that will be considered as a void contract. Okay? Next, source of obligation is acts or omissions punishable by law, or what we call delicts or crime. Okay? In the case of Neplum versus Orbeso, the Supreme Court said that when a criminal action is instituted, it is deemed instituted with the criminal action, the civil liability arising from the crime, okay, or ex delicto, but not those liabilities from quasi-delicts, contracts, or quasi-contracts. Ibig sabihin, that when a person commits a crime, meron siyang dalawang liability. Criminal liability and civil liability arising from the crime committed. Because according to the Supreme Court, when a person commits a crime, he offends two entities. That is the society in which he lives in, or the political entity called the state, whose law he has violated, and the individual member of that society whose person, right, honor, or chastity, or property was actually or directly injured or damaged by the same punishable act or omission. Okay? However, there are instances na wala pong civil liability, okay, arising from the crime committed because there is no material damage or there is no private person injured, just like in the case of treason, rebellion, or contempt. So dito sa mga crimes na ito, there is no civil liability to be enforced. Okay? But the general rule is that for all criminal acts committed, meron pong kaakibat na civil liability. Okay? Ano yung included sa civil liability arising from the crime? Sabi ng Korte Suprema, we have three. We have restitution, reparation for the damage caused, and indemnification for consequential damages. Okay? Example, halimbawa, to illustrate yung tatlong liabilities, okay, from the crime. Let's say, Davi stole the gold ring of John Albert. Okay? So, nag-commit siya ng crime. Ngayon, if Davi is convicted, the court can order Davi to return the gold ring or to pay its value if it was lost or destroyed. That's the first one. Or second, to pay for any damage caused to the gold ring and to pay such other damages suffered by John Albert as a consequence of the crime. So yun po yung inclusion ng civil liability arising from the crime committed. Okay? Question. What if the accused is acquitted? Paano kung na-acquit si accused? Meron pa bang civil liability? Answer. It depends on the reason of the acquittal. So titignan natin ano yung rason ng acquittal. Okay? If the acquittal is an acquittal on the ground that the accused is not the author of the act or omission complained of, wala pong civil liability to be enforced arising from the crime charge. Because sabi ng Supreme Court, a person who has been found to be not the perpetrator of any act or omission cannot and can never be held liable for such act or omission. So, kapag na-acquit, because hindi siya yung gumawa ng act or omission complained of, wala kang civil liability. Okay? But if the acquittal is based on reasonable doubt on the guilt of the accused, he is not exempt from civil liability which may be proved by preponderance of evidence only. Yan ang sabi ng ating Korte Suprema. Therefore, kapag na-acquit yung accused, hindi po siya exempted from civil liability if the acquittal is based on reasonable doubt. Second, the civil liability does not arise from the crime on which the acquittal is based. And third, the court declares that the civil liability or the liability of the accused is only civil. Okay? So hindi po porket na acquit yung accused, exempted na siya from civil liability. Okay? Now, sabi ko kanina, when a criminal action is instituted, the civil action for the recovery of the civil liability arising from the offense charge shall be deemed instituted with the criminal action. Unless, okay, the offended party waives the civil action, reserves the right to institute the civil action separately, or institute the civil action prior to the criminal action. This is under the rules of court. Okay? Now, under reservation, bawal pong magkaroon ng reservation in BP22 cases. Okay? Bakit? Ang sabi ng Supreme Court, bakit hindi allowed ang reservation sa BP22? Because the payee uses the intimidating effect of a criminal charge to collect his credit gratis or freely. And sometimes, upon being paid, the trial court is not even informed thereof. So sabi ng Korte Suprema, kapag nag-file ka ng BP22 case, deemed instituted yung civil liability for the BP22 case and bawal pong magkaroon ng reservation. Okay? Except in two instances. Pwede daw magkaroon ng reservation in BP22, okay, if the civil action is filed ahead of the criminal case. Pero sabi ng Supreme Court, even then, kahit na naunang may file yung civil action ahead of the criminal case, the rules encourage the consolidation of the civil and the criminal cases. Okay? That's the first exception. Second exception is that in case when a check is issued in the name of corporation, okay, sabi ng Korte Suprema, pwedeng mag-proceed yung BP22 case. In the BP22 case, what the trial court should determine whether or not the signatory had signed the check with knowledge of the insufficiency of funds or credit in the bank account, while yung civil case na isa, the trial court should ascertain whether or not the obligation itself is valid and demandable. Sabi ng Korte Suprema dito, the litigation of both questions could, in theory, proceed independently and simultaneously without being ultimately conclusive on one or the other. So, ibig sabihin, pwedeng mag-proceed, okay, independently yung civil case. But the general rule in BP22 cases, bawal pong magkaroon ng reservation except in these two instances. Okay? Last, on delict. What if the accused died before the finality of judgment or pending appeal? Meron pa ba siyang civil liability? Okay? Kapag namatay siya bago yung finality ng judgment or habang umaapela siya. Sabi ng Supreme Court in the case of People versus Bayotas, the death of the accused pending appeal of his conviction extinguishes his criminal liability as well as the civil liability based solely thereon. Therefore, the civil liability based on the crime is extinguished. But if there are other sources of obligation, the claim for civil liability survives notwithstanding the death of the accused if the same civil liability may also be predicated on a source of obligation other than delict. So kung may iba pang sources ng obligation, okay, pwede pong mag-survive yung civil liability. And the civil liability arising from other sources remains and may be filed against the executor, administrator, or estate of the accused. Okay? Sabi ko kanina, there are other sources of obligation. Ito yung panglima na source of obligation. One of the sources of obligation under 1157 is quasi-delict. What is a quasi-delict? Quasi means it is akin to or similar to but not exactly the same. So it is like a crime but not exactly as a crime. Yun yung ibig sabihin ng quasi-delict. Or the Civil Code under 2176 defines quasi-delict as an act or omission by a person which causes damage to another in his person, property, or rights, giving rise to an obligation to pay for the damage done, provided there must be fault or negligence, but there is no pre-existing contractual relation between the parties. Okay? Example of quasi-delict in this case of Garcia versus Judge Florido, the Supreme Court characterized the violation of traffic rules as a quasi-delict or culpa aquiliana because sabi ng Korte Suprema, the violation of traffic rules is merely descriptive of the failure of the driver to observe for the protection of the interests of others that degree of care, precaution, and vigilance which circumstances justly demand na nagresulta sa injury on claimants. So sabi ng Korte Suprema dito, this is a quasi-delict. Okay? Requisites of quasi-delict, there must be an act or omission by the defendant. There must be fault or negligence on the part of the defendant, and there must be damage caused to the plaintiff. And take note that the law also requires that there must be a direct relation or connection of cause and effect between yung ginawa or yung omission ni defendant and the damage caused to the plaintiff or to the injured party. And take note that there must be no pre-existing contractual relation between the parties. Okay? However, sabi ng Supreme Court, kahit na may contractual relation between the parties, we can still apply the rule on quasi-delict. Okay? In this case of PSBA versus Court of Appeals, ang sabi ng Korte Suprema, okay, if the act which breaches a contract be done in bad faith and be violative of Article 21 of the Civil Code, kahit na may kontrata, okay, then the act can be considered as a quasi-delict, provided, okay, the act which breaches the contract be done in bad faith and it is violative of Article 21 of the Civil Code. So kahit merong pre-existing contractual relation, pwede pa rin daw pong i-apply ang rules on quasi-delict. Okay? What is the coverage or scope of quasi-delict? Quasi-delicts cover not only acts not punishable by law, but also acts criminal in character, whether intentional and voluntary or negligent acts. Therefore, yung mga intentional and voluntary act may produce two kinds of civil liability. Okay? Yun po yung civil liability arising from quasi-delict under 2176. This is what we call the culpa aquiliana or quasi-delict. And the civil liability arising from the crime. Okay? However, take note that there is a limitation. This is the no double recovery, meaning to say, the law expressly prohibits the plaintiff or the injured party from recovering damages twice under delict and quasi-delict for the same act or omission of the defendant. Ang ibig sabihin nito, no double recovery, sabi ni Justice Barredo in the case of Padua versus Robles, this means that if there are varying amounts awarded into two separate cases, the plaintiff or the injured party may recover only the bigger amount. If he had been paid a bigger amount in one case, he may no longer recover in another case. Okay? Now we go to nature and effects of obligation. Short discussion lang dito. Okay? Take note that the obligation may be classified from the viewpoint of the prestation or kind of prestation involved in the obligation. So, dalawa yan po pwedeng real obligation and personal obligation. And when we say real obligation, this involves an obligation to give or to deliver. Dalawang klase din po yan. Pwedeng determinate obligation and indeterminate obligation or generic obligation. And when we say determinate obligation, kapag sinasabi nating determinate, yung object is particularly designated or physically segregated from all others of the same class. Indeterminate or generic, okay, ang naka-indicate lang is yung genus of the thing. Okay? Personal obligation, this involves an obligation to do or not to do. Okay? I'd like to emphasize lang on determinate obligation on the duties of the debtor in determinate obligation. Take note that one of the duties of a debtor in determinate obligation is to deliver all accessions and accessories of the thing, even though hindi po na-mention yung delivery ng accessions and accessories. Okay? Accessions means all of those things which are produced by the thing, which is the object of the obligation, while accessories refer to those things which have for their object yung embellishment, use, or preservation of another thing. Example ng accession, the profits or dividends accruing from shares of stock. While accessories, ito yung mga equipment or tools of a factory or the key of a house. Yun yung mga examples ng accessories. So I repeat, in cases of determinate obligation, the debtor has the duty to deliver all accessions and accessories of the thing, even though they have not been mentioned. Okay? But take note that the obligation to deliver the accessions or accessories of a thing does not include the thing. I repeat, if what is involved is an obligation to deliver the accessions or accessories of a thing, it does not include the thing unless otherwise stipulated. Like in this case, in the case of Formeliosa versus Land Tenure Administration, the sale of a house and improvements upon a land is not sufficient to convey title or any right to the land. Kasi sabi ng Supreme Court, yung obligation na mag-deliver ng accession will not include the thing. Okay? Now we go to breach of obligations. Ano-ano yung mga different modes of breach of obligations? We have two classifications, voluntary and involuntary breach. And under voluntary, we have 4, mora or delay, we have dolo or fraud, we have culpa or negligence, and contravention of the tenor of the obligation. While in the case of involuntary breach, we have fortuitous event or force majeure. Okay? Magdi-discuss lang ako ng ilan dito, okay? Because of our limited time. We have mora or delay. Okay? We have 3 kinds. Mora solvendi. This is the delay or default on the part of the debtor to fulfill his obligation. We have also mora accipiendi. This refers to a situation where the debtor offers to perform the prestation, but the creditor refuses to accept without just cause. And we have compensation mori, the delay on the parties or of the parties or obligors in reciprocal obligations. Okay? Take note that for a debtor to be considered in delay or in default, we have certain requisites. First, the obligation is demandable and already liquidated. Second, the obligor or debtor delays performance. And take note number 3, the creditor should require the performance judicially or extrajudicially. Okay? Sabi ng Supreme Court, kahit na hindi nagpe-perform si debtor or obligor ng kanyang obligation, if there is no judicial or extrajudicial demand by the creditor, wala po tayong matatawag na delay on the part of the debtor. Okay. Judicial meaning to say, creditor files a complaint against the debtor for the fulfillment of the obligation, while extrajudicial, meaning to say, creditor demands from the debtor the fulfillment of the obligation either orally or in writing. Okay, illustrate natin para maintindihan nyo. Let's say, Dabi borrowed a sum of money from John Albert noong October 1, 2020. Sabi niya, babayaran niya yung obligation ng October 1, 2021. Okay? However, despite na dumating na yung October 1, 2021, hindi nagbayad si Dabi, pero hindi rin nag-demand si John Albert. Nag-file lang ng case si John Albert ng October 1, 2022. Okay? Question here, from what time shall the legal interest be computed? Dun ba sa October 1, 2021 or from October 1, 2022 when the complaint was filed? Okay? According to the decided cases, the interest shall be computed from October 1, 2022, that is from the time the complaint was filed, because it was only then that the debtor had incurred in delay. Kasi sabi natin, ang requisites po para magkaroon ng delay on the part of the debtor, there must be a judicial or extrajudicial demand by the creditor. Kapag wala pong demand, wala po tayong matatawag na delay. Okay? Except, may mga certain exceptions tayo. Ibig sabihin, hindi na necessary ang demand para magkaroon ng delay. Unang exception is when the law or agreement of the parties expressly so declare. Kapag may batas na nagsasabi or the agreement of the parties expressly so declare. However, there are certain exceptions to the requirement of demand. Ibig sabihin, kahit na walang demand, pwede nang magkaroon ng delay on the part of the debtor. First is when there is a law or when the agreement of the parties expressly so declare that demand is no longer necessary. Or number two, from the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of a contract. So halimbawa, yung delivery ng balloons on a particular date when a children's party will be held, or the making of a wedding dress where the wedding is scheduled at a certain time. So kapag hindi na deliver at those particular dates, hindi na necessary ang demand. Okay? Another exception is when demand would be useless, as when the obligor has rendered it beyond his power to perform. Just like in this example, if Dabi promised to deliver a specific car to John Albert on December 5, okay? However, a few days after the said date or a few days after the agreement, the car was completely destroyed through Dabi's fault. So in that case, demand by John Albert would be useless na. Okay? Another exception in cases of reciprocal obligations. Okay? In reciprocal obligations, one party incurs in delay from the moment the other party fulfills his obligation. So, hindi na po kailangan ng demand. Kapag nag-perform na yung other party at yung isang party hindi pa nagpe-perform ng kanyang obligation, hindi na kailangan ng demand para magkaroon ng delay. The other party who's not yet ready to comply with his obligation is now in delay. Okay? But take note dito ha, in reciprocal obligations, the parties may agree that performance may be set on different dates. Okay? So kapag may sinet silang different dates for the performance of their obligation, demand is needed para magkaroon ng delay. Just like in a contract of sale, okay? In a contract of sale where it was stipulated by the parties that delivery may be made on December 5, while payment by the buyer may be made on January 5 the following year. So, kailangan po magkaroon ng demand to put the seller in default even if the obligation is a reciprocal one. But if wala pong napag-agrihan na different dates on performance, the moment the other party is ready to comply with his obligation, but the other party is not yet ready to comply, then that other party who's not yet ready to comply with his obligation is already in delay. Hindi na po necessary ng ang demand. Example, dito, Dabi sold his car to John Albert for 900,000. They agreed that delivery and payment shall be made on December 5, 2020. On that date, Dabi was not ready to deliver the car, neither was John Albert ready to pay. So, on both sides, wala pang delay. However, if Dabi delivered or was ready to deliver the car on that date, but John Albert did not pay or was not ready to pay, then John Albert is said to have incurred in delay. Hindi na po necessary ang demand from Dabi. Okay? So take note of that. Now we go to involuntary breach. This is under 1174 fortuitous events. Okay? What is a fortuitous event? Sabi ng Supreme Court, a fortuitous event is any extraordinary event which cannot be foreseen or which, though foreseen, is inevitable. In other words, these are events that are either impossible to foresee or impossible to avoid. Okay? They may be produced by two general causes, by nature, such as earthquakes, storms, floods, epidemics, or fires, or by the act of man, just like armed invasion, attack by bandits, governmental prohibitions, robbery, etc. Okay? It can be classified into two. Fortuitous event can be classified into two. We have fortuitous event proper, or acts of God, and we have force majeure or fuerza mayor, depending upon whether there is human intervention or not. Yung acts of God or fortuitous event proper refers to an event which is absolutely independent of human intervention, while the second refers to an event which arises from legitimate or illegitimate acts of persons other than obligor. But in either case, okay, kahit na yan ay fortuitous event proper or force majeure, kapag present po ang fortuitous event, the debtor fails to perform his obligation in the ordinary manner. Okay? Requisites of fortuitous event, apat. We have number one, the event must be independent of the human will or at least of the obligor's will. Second, the event could not be foreseen, or even if it could be foreseen, it must be impossible to avoid. So the element of unforeseeable and unavoidable. Third, the event must be of such character as to render it impossible for the debtor to comply with his obligation in the normal manner. And take note, number 4, the obligor must be free from any participation or in the aggravation of the injury to the creditor or to the obligee. I-discuss natin tong requisites through some cases, okay? Decided cases. Let's take the case of Southeastern College versus Court of Appeals. Anong nangyari dito? Okay? Merong bagyong saling. Natuklap yung bubungan nung Southeastern College, nalipad at nag-cause ng damage sa mga katabing bahay. Okay? Ang issue dito was that whether the damage on the roof of the building of the private respondents, yung mga katabi ni Southeastern College, resulting from the impact of the falling portions of the school building's roof, Reef off by the strong winds of Typhoon Saling was within the legal contemplation due to a fortuitous event. Considered ba daw yon as a fortuitous event? Anong sabi ng Supreme Court? Okay? There's no question na yung typhoon or storm is a fortuitous event because it is a natural occurrence which may be foreseen but is unavoidable despite any amount of foresight, diligence, of care. But take note, sabi ng Korte Suprema dito sa Southeastern College, the person invoking fortuitous event to be exempt from liability must be free from any participation amounting to negligent act. Ibig sabihin, the person invoking fortuitous event must not be guilty of negligence. Okay? Negligence meaning to say the failure to observe that degree of care, precaution, and vigilance which the circumstances justly demand. Okay? Dito, sa case ni Southeastern College, ang sabi ng Supreme Court, there was no evidence that Southeastern College was negligent. Okay? Bakit? Una, sabi ng Supreme Court, there was no investigation conducted to determine the real cause of the partial unroofing of the petitioner's school building. Neither did they prove any substantial deviation from the approved plans and specifications, nor did they conclusively establish that the construction of such building was basically flawed. So dun pa lang sabi ng Supreme Court, malabong mapatunayan na merong negligent act on the part of Southeastern College. Second reason is, sabi ng Supreme Court, Southeastern College obtained both building permit and certificate of occupancy, okay, as part of the regular inspection and proper construction of subject school building. So, meron silang building permit and na-comply nila yung tinatakda ng LGU for the proper construction through the certificate of occupancy issued. Okay? Third, sabi ng Supreme Court, when part of its roof needed repair or repairs of the damage inflicted by Typhoon Saling, the city official gave the go signal for such repairs without any deviation from the original design. So ibig sabihin, sabi ng Korte Suprema, the building suffers no structural defect, contrary to what has been reported that it was structurally defective. And lastly, the city building official who has been in the city government service since 1974 admitted that no complaint regarding any defect on the same structure has ever been filed before his office prior to the institution of the case against Southeastern College. So sabi ng Korte Suprema, the invocation of fortuitous event by Southeastern College is valid. Hence, Southeastern College may be exempt from civil liability. Okay? However, i-differentiate natin to sa case ni Sikam versus George or Jorge. Okay? Illustrating the principle that the person invoking fortuitous event must not be guilty of negligent acts. Dito sa case na to, ang nangyari dito, nagkaroon ng robbery in the Sikam Pawn Shop, ahensya de R. Sikam Pawn Shop, at tinangay ng two armed men lahat ng cash and alahas found inside the pawn shop. One of the clients, si Lulu George, filed a case, okay, seeking indemnification for the loss of the jewelry and payment of actual and moral and exemplary damages as well as attorney's fees. Sabi ni Sikam, it should not be made liable because it had exercised due care and diligence in the safekeeping of the articles pledged with it. and it could not be made liable for an event that is fortuitous. So sabi niya, yung robbery daw is considered as a fortuitous event. Anong sabi ng Korte Suprema dito? Again, sabi ng Supreme Court, a person invoking fortuitous event must not be guilty of negligent acts. Okay? Dito sa case ni Sikam, ang sabi ng Supreme Court is that at the time na nag-open ng business si Sikam in 1983, he was already thinking of opening a vault with the nearby bank for the purpose of safekeeping the valuables, but he was discouraged by the central bank. Sabi ng Supreme Court, the very measures which petitioners had allegedly adopted showed that to them, the possibility of robbery was not only foreseeable but actually foreseen and anticipated. Ibig sabihin, this is contrary to the defense of fortuitous event because, balikan natin yung requirements, it must be unavoidable or it must be, now second requirement is that it must not be foreseen, or if though foreseen, it is impossible to avoid. Dito sa case ni Sikam versus George, sabi ng Korte Suprema, the very measures which petitioner Sikam had adopted, yung pag-open dapat niya ng vault, dahil may mga nababalitaan na siya na robbery in the nearby areas, okay? Sabi ng Korte Suprema, it showed to them the possibility of robbery was not only foreseeable but actually foreseen and anticipated. And sabi ng Supreme Court, additional, the facts of the case or the testimony of Sikam reveals that there were no security measures adopted by Sikam in the operation of the pawn shop. In fact, there was no clear showing that there was any security guard at all, or kahit meron, he had sufficient training in security, in securing a pawn shop. So sabi ng Korte Suprema, there were evidence of negligence on the part of Sikam. So according to the Supreme Court, Sikam cannot invoke fortuitous event in this particular case. Okay? Take note that in cases of fortuitous event, the general rule is that the debtor is not liable if there is a fortuitous event, except when the law or the stipulation of the parties or the nature of the obligation expressly so declare that in case of fortuitous event, the debtor is still liable. Okay? So kapag may batas daw na nagsasabi or napag-agrihan ng mga parties, or when the nature of the obligation requires the assumption of risk, liable pa rin si debtor, even if there is a fortuitous event. Example of nature of obligation, classic example dito in cases of insurance contracts, okay? Because that really requires the assumption of risk, okay? So kahit na may fortuitous event, debtor is still liable, okay? Now we go to the kinds of obligation. We have 6 kinds of obligations. Pure and conditional obligations, obligation with a period or term, alternative and facultative, joint and solidary, divisible and indivisible, and obligation with a penal clause. I-discuss ko lang po yung iba dito and yung mga rules under each kind of obligation. So, nakikinig pa rin kayo? So, kung nakikinig pa rin kayo sa lecture ko ngayon, kindly type VLC sa comment section kung nakikinig pa rin kayo at klaro pa rin yung ating discussion. Okay? So, we'll start with pure and conditional obligation and obligation with a term or period. So, from the point of view of the presence or absence of a condition or term or period, pwede nating maklasify ang obligation into pure that is an obligation that is not subject to any condition or term. Pwede ding conditional obligations. Ito yung mga obligation that is subject to a condition, and obligations with a term or period. These are obligations that are subject to a term or period. Okay. Example of pure obligations, I promise to pay you 1 million, or I'll pay you 12 million on demand. Okay? So these are pure obligations. They are not subject to any condition or term. So we continue with the kinds of obligations. So we have 6 principal kinds of obligations under the Civil Code. We have pure and conditional obligations, obligation with a period or term, alternative and facultative obligations, joint and solidary obligations, divisible and indivisible obligations, and obligation with a penal clause. I-discuss ko lang yung iba dito and titignan natin yung rules sa mga obligations that will be discussed. Okay? We start with the 3, pure and conditional, and obligation with a period or term. So pwede daw maklasify ang obligation depende sa presence or absence ng condition or term. So pwedeng pure obligation if the obligation is not subject to a condition or term. Pwede din namang conditional if the obligation is subject to a condition. Or po pwede din namang obligation with a term if the obligation is subject to a term or period. Okay? Example of pure obligation is, I promise to pay you 1 million. That is not subject to any condition or term. Okay? Pag sinabi naman nating conditional obligation, ito yung mga obligation na nakasubject sa condition. Ano ba yung condition? Sabi ng batas, ang condition daw is a future and uncertain event. Take note future and uncertain event na kapag nangyari sila, po pwedeng magkaroon ng obligation, it will give rise to the obligation, or it will give birth to the obligation, effectivity of the obligation, or extinguishment of the obligation or rights. Okay? Example, Dabi promises to pay Patrick 500,000 if Patrick can prove by proper evidence that COVID-19 really originated from a laboratory in Wuhan and not from bats. Okay? So magbibigay ng 500,000 piso kay Patrick kapag napatunayan ni Patrick na nag-originate ang COVID-19 sa laboratory sa Wuhan at hindi sa mga panike or from bats. Magkakaroon pa lang ng obligation to pay 500,000 if napatunayan. Pag hindi napatunayan ni Patrick, if walang proper evidence, okay, na nag-originate talaga yung COVID-19 sa laboratory in Wuhan, then walang magkakaroon or walang obligation on the part of Dabi. Okay? So sabi ng batas, ang mga obligation daw na nakasubject sa condition, mga future and uncertain event, dalawa yung po pwede niyang maging effect. Either birth of the obligation or effectivity of the obligation, or kapag nangyari yung mga condition, po pwede ring ma-extinguish yung obligation. Okay? Kinds of conditions, we have suspensive and resolutory. Meron din tayong potestative, casual, mix. Meron din tayong positive and negative, impossible and possible conditions, and divisible and indivisible conditions. Okay? Tignan lang natin yung principal. Ito yung suspensive and resolutory. Okay? When we say suspensive, these are conditions na kapag nangyari sila, it will give rise or birth to the obligation of the debtor to perform and the right of the creditor to demand. Okay? Ibig sabihin nito, kapag nangyari yung yung condition or yung event, dun pa lang magkakaroon si debtor ng obligation to perform. Kapag hindi nangyari, wala pong obligation si debtor na ipe-perform at wala ding karapatan si creditor na mag-demand ng performance. But take note, kapag nangyari yung condition, the effects of a conditional obligation, particularly an obligations to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Meron siyang retroactive effect. Kapag nangyari yung condition, babalik siya, magre-retroact siya to the day of the constitution of the obligation. Okay? Example, para makita ninyo itong illustration ng retroactivity. In 2016, Dabi promised to give John Albert a land. Provided, sabi ni Dabi, papasa si John Albert ng CPA board exam in 2020. Ngayon, nung 2020, pumasa si John Albert ng board exam. Anong ibig sabihin ng retroactivity? It is as if John Albert was already entitled to the land beginning 2016. Therefore, any contract made by John Albert in 2016 or before the happening of the condition, ano yung condition dito? Yung pagkapasa niya ng board exam. Okay? Before mangyari, if there's any contract entered into by John Albert before passing, will be considered valid. Okay? Yan yung ibig sabihin ng retroactive effect of a suspensive condition. So, any alienation on the part of Dabi prior to the happening of the condition, kapag nangyari yung condition, should be considered invalid because prior to the happening, kapag nangyari na yung condition from 2016, considered na as if pagmamayari na ni John Albert yung lupa. Okay? But take note, ang general rule natin dito is that the effects of conditional obligation shall retroact except as to the fruits and interest. Okay? In unilateral obligation, ibig sabihin yan, the debtor gets the fruits unless there is an agreement to the contrary. But in reciprocal obligations, the fruits and interest during the pendency of the condition shall be deemed to compensate each other for purposes of convenience. Okay? Example, in 2019, si Dabi nag-agree siya na ibenta yung kanyang lupa kay Irali. Okay? Irali agreed to pay provided John Albert passes the 2020 bar exam. Okay? So si John Albert pumasa nga ng bar exam ng 2020. Now, Dabi must now give the land to Irali and Irali must pay the price. Okay? However, the fruits of the land from 2019 up to 2020 will remain with Dabi for purposes of convenience. Kasi sabi ng batas, okay, shall be deemed to compensate each other. So, hindi na po kasamang ibibigay yung mga fruits of the land from 2019 up to 2020. Irali, on the other hand, will keep the interest on her money. Okay? Kasi, di ba, dapat ibigay din nila kasama yung fruits of the property from the time na ma-constitute yung obligation hanggang sa ma-fulfill yung condition, dapat kasama siya. Pero sabi ng batas, for purposes of convenience, hindi na siya kasamang ibibigay. It will remain with the debtor and it will remain with the creditor. Okay? Now, in resolutory conditions, what is a resolutory condition? Ito, kabaliktaran to ng suspensive. In resolutory, ito yung mga conditions na kapag nangyari sila, it will produce the extinguishment of the obligation. So, ibig sabihin, kapag yung obligation nakasubject sa resolutory condition, yung obligation is already demandable. But, subject to the happening of the condition, na kapag nangyari nga, sabi ko, yung condition, it will produce the extinguishment of the obligation. Example, Dabi gave John Albert a parcel of land on the condition that John Albert will never go to any nightclub. However, 3 weeks after na mag-agree sila or mabigay ni Dabi yung lupa, John Albert went to a nightclub in Quezon Avenue. Anong effect kapag nangyari yung condition? Ano yung condition dito? That you will never go to any nightclub. Yun yung condition. Ngayon nangyari kasi pumunta siya. Anong mangyayari sa obligation ni Dabi? Dabi's obligation will be extinguished. It will be considered that Dabi had no obligation at all. On the part of John Albert, kapag nangyari yung condition, he will have the obligation to return both the land and the fruits he had received from the moment Dabi had given him the land. Yan yung effect kapag nangyari ang resolutory condition. But take note, when the obligation is subject to a resolutory condition, the obligation is demandable at once. Okay? Now, there are obligations, what we call reciprocal obligations na may characteristic ng resolutory condition. Okay? Ibig sabihin, in reciprocal obligations, kapag yung one party violated his undertaking or violated his obligation, pwede pong magresulta sa rescission or resolution, okay, of the obligation or the right to rescind the contract. If there is a breach of faith by the other party that violates the reciprocity between them. Meron siyang, sa mga reciprocal obligations, meron itong characteristic ng resolutory. Kasi kapag sa reciprocal obligations kasi, di ba, in reciprocal obligations, these are obligations na on both sides, meron kayong obligation. But the cost must be identical and the obligation should arise simultaneously. So kapag yung isang party does not comply or violated, there is a breach of faith, okay, pwedeng i-rescind ng injured party, okay, yung kontrata. Or sabi ng Supreme Court, resolution under 1191. This is actually resolution under 1191. For example, in a contract of sale of car, the delivery of the car sold by the seller is conditioned upon the simultaneous payment of the purchase price by the buyer and vice versa. So ito yung sinasabi nating example ng reciprocal obligation. Okay? Seller is the creditor as to the price and debtor as to the car, while si buyer siya yung creditor as to the car and debtor as to the price. Hindi po nag-a-apply ang rescission kapag hindi reciprocal yung obligation. Okay? Nag-a-apply lang ang rescission under 1191 sa mga reciprocal obligation. Halimbawa, okay? There are obligations na merong characteristic ng resolutory condition or meron silang resolutory character. Ito yung mga obligations na reciprocal. Tinatawag nating mga reciprocal obligations. Okay? Sabi ng batas under 1191, the power to rescind is implied in reciprocal obligations. Ibig sabihin, if there is a breach of faith by the other party that violates the reciprocity between them, the injured party has given the right to rescind or ask for the rescission of the contract, or sabi ng Korte Suprema, resolution of the contract under 1191. But take note that rescission or resolution under 1191 applies only to reciprocal obligations. Ibig sabihin, the cost must be identical and the obligations should arise simultaneously. Example, in a contract of sale of car, okay, the delivery of the car sold by the seller is conditioned upon the simultaneous payment of the purchase price by the buyer and vice versa. So on the part of the seller, siya yung creditor as to the price, pero siya yung debtor as to the car, while the buyer is the creditor as to the car and debtor as to the price. So ito, example ng reciprocal obligation. Okay? So sabi ng 1191, nag-a-apply lang daw ang remedy ng rescission sa 1191, okay, if the obligation involved is a reciprocal obligation. Hindi po yan nag-a-apply sa mga hindi reciprocal obligation, just like in this example. Okay? Dabi borrowed 10,000 from Neptali under a contract of loan. Okay? Dabi, on the other hand, is the owner of a place where Neptali deposits for safekeeping his car. And because of that contract between Dabi and Neptali, Neptali owes Dabi 5,000 for deposit fees. Meron silang obligations both sides. But, okay, the cost does not arise from the same contract. Kasi yung unang contract is arising from a contract of loan, while the other contract, the second contract, is arising from the contract of deposit. So in this case, kahit both parties are mutually bound, hindi nag-a-apply ang rescission. So take note, nag-a-apply lang ang rescission sa mga reciprocal obligations. Okay? Ano ang remedies ng injured party under 1191? Okay? The injured party has the right to choose between rescission or fulfillment of the obligation with the right to claim damages in either case. So dalawa ang pwede niyang pamilian. Pwede siyang mag-ask ng rescission or pwede siyang humingi ng fulfillment or performance of the obligation. But in either case, right to claim damages. Okay? Take note, guys, that the remedy here is alternative. Ibig sabihin, isa lang ang pupwedeng piliin. Bawal ang dalawa. Okay? But if the injured party has already chosen specific performance, he may ask for rescission if a specific performance becomes impossible. Kung una niyang hiningi ang specific performance at hindi na ma-perform ng other party yung kanyang obligation, then po pwede nang hingin ng injured party yung specific performance. Okay? If the injured party asks for specific performance, he cannot thereafter ask. So what are the remedies of the injured party under 1191? Okay, dalawa. The injured party has the right to choose between rescission or fulfillment of the obligation. But in either case, pwede siyang mag-claim ng damages. Take note that the injured party has an alternative remedy. Ibig sabihin, isa lang ang pwede niyang piliin, hindi both rescission and fulfillment. Okay? But take note that if the injured party has chosen specific performance, kapag inuna niya ang specific performance but it becomes impossible, he may ask for rescission. Okay? But if the injured party already asked for rescission, he cannot thereafter ask for specific performance. Okay? Now, take note that ang sabi ng batas and ang sabi ng Supreme Court, the power of rescission must be invoked judicially. Ibig sabihin, there must be a judicial intervention or court intervention. It cannot be exercised solely on a party's own judgment that the other has committed a breach of the obligation. So dapat merong intervention. You must file a case for rescission before our courts para ma-invoke mo yung power of rescission. Except, okay, when there is a provision in the contract empowering a party to rescind it without resort to the courts, then, sabi ng Supreme Court, judicial permission to cancel is no longer necessary. Okay? What are some limitations on the right to ask for rescission? Take note na kahit may breach of the obligation or may quote-unquote breach of the obligation, the injured party cannot right away ask for the rescission of the contract if there is merely a slight or casual breach of the obligation, or rescission cannot be demanded by the injured party if he is no longer in position to return what he had received under the contract. And of course, rescission cannot be granted when the object of the contract is already in the possession of a third person who has not acted in bad faith. So in these three cases, okay, ito yung mga limitation ng right of ng injured party to ask for rescission. Okay? Effects of rescission under 1191, it has the effect of abrogating the contract in all parts. Ibig sabihin, unmaking of a contract or its undoing from the very beginning and not merely its termination. Hence, rescission creates the obligation to return the object of the contract. Ibig sabihin, to rescind means to declare a contract void at its inception and to put an end to it as though it never was. Okay? Yan po ang effects ng rescission under 1191. Last on rescission, take note, yung rescission sa 1381 is merely a subsidiary action limited to cases in 1381 and can only be instituted when the other party has no other legal means to obtain reparation for the damage. And yung rescission sa 1381 is based on lesion or fraud upon creditors. Okay? While in rescission in 1191, it is a principal remedy that is based on breach of faith by the other party. And it applies exclusively to reciprocal obligations, yung rescission sa 1191. While the rescission in 1381 in rescissible contracts applies to all kinds of obligations arising from contracts, whether the contract is reciprocal or not. Okay? So take note of that difference. Now we go to obligation with a term or period. Nakikinig pa rin po ba kayo? Kindly type VLC in the comment section if nakikinig pa rin kayo and clear pa yung boses ko. Okay? Now we go to obligation with a term or period. These are obligations whose consequences are subjected in one way or another to the expiration of said term or period. Examples, as soon as I have money, in partial payments, or when the debtor is in a position to discharge his obligation. Okay, yan po mga examples ng obligation with a term or period. Take note lang ang mga rules dito sa obligation with a term or period. First, when in an obligation with a period, okay, it is presumed that the period is established for the benefit of both the creditor and debtor. I repeat, sa mga obligation with a period or term, it is presumed that the period or term is established for the benefit of both the creditor and debtor, unless it should appear that the period has been established in favor only of one party. Anong ibig sabihin nito? Ibig sabihin kung established for the benefit of the creditor and debtor, the debtor cannot pay prematurely and the creditor cannot demand prematurely the performance of the obligation. But okay, if the period was established for the benefit of the creditor only, creditor can demand at any time kasi na-establish yung benefit ng period para sa kanya even before the term expires. And he cannot be compelled to accept payment from the debtor prior to the stipulated period. Example, Dabi promised to pay on December 1, 2020 with the creditor given the right to demand performance even before said date. So prior to December 1, dahil na-establish yung period for the benefit of the creditor, prior to December 1, bawal pong i-compel si creditor to accept payment. Okay? Kasi na-establish yung benefit ng period para kay creditor. But if the period was established for the benefit of the debtor only, he is required to pay only at the end. And he may pay even before the arrival of the period. Okay? Pero bawal po siyang i-compel na magbayad or mag-perform prior to the arrival of the period. But he has the right to perform or pay even before the arrival of the period. Okay? So take note of that. Take note also that when the debtor has been given the benefit of the period, he can lose the benefit of that period in these instances. Okay? One instance is that when the debtor attempts to abscond, or when the debtor violates any undertaking, or when the obligation, after the constitution of the obligation, he becomes insolvent unless he gives another security for the debt. Ibig sabihin, kapag present tong instances na to, the debtor loses the benefit of the period, meaning that the term is extinguished and the obligation becomes an obligation demandable at once. Okay? Now we go to alternative and facultative obligation. When we say alternative obligation, this is an obligation wherein various prestations are due, but the performance of only one of them is sufficient. Okay? In facultative naman, there is only one obligation or prestation, but the debtor may render another in substitution. Example, alternative, halimbawa, si Dabi umutang kay Alma ng 10,000. It was agreed that Dabi could comply with his obligation by giving Alma 10,000. So, pwedeng ma-extinguish ang obligation niya pag nagbayad siya ng 10,000. Or nagbigay siya ng color television set or by painting the house of Alma. Okay? So kahit ano dyan ang piliin niya, as long as tanggapin and ma-communicate kay creditor, the obligation of Dabi will be extinguished. In facultative obligation, there is a main obligation or prestation, but the debtor may render another as a substitute. Example, I will give you my piano, but I may give my television set as a substitute. So the main prestation or the main obligation is the giving of piano. Substitute dito is yung giving of television set. Okay? Take note lang yung rule in alternative obligation, the right to choose kung ano yung ipe-perform always belongs to the debtor. Except kung yung right to choose from among the prestations involved, nabigay po yan kay creditor. But the right must be expressly granted to the creditor. If wala pong naka-indicate sa problem, or if wala pong naka-indicate sa agreement, the right to choose always belongs to the debtor. Okay? Take note of that. Okay? But, sabi ng Supreme Court, according to Justice Leonen, the choice of the debtor must be communicated to the creditor who must receive notice of the choice. Okay? Because anong purpose ng notice na to? To give opportunity to the creditor to express his consent or to impugn the election made by the debtor. And only after said notice shall the election take legal effect when consented to by the creditor, or when declared proper by a competent court. Okay? So take note of that. Now we go to joint and solidary obligation. Joint obligation is one where the whole obligation is to be paid or fulfilled proportionately to each his own. Halimbawa, Allen and Dabi are joint debtors of Patrick to the amount of 1 million. Dahil proportionate to each his own, si creditor, Patrick, can only demand 500,000 from Allen and only 500,000 from Dabi. Yan po ang example ng joint obligation. Pag sinasabi naman nating solidary, ito naman, debtor. But here in solidary obligation, the creditor can ask the entire performance or the whole amount of 1 million from one debtor alone. Okay? This is a solidary obligation. Ano ang rule sa joint and solidary obligation? General rule, always in favor of joint. Kapag walang naka-indicate na yan ay solidary, always rule in favor of joint obligation. Unless there is a stipulation in the contract that the obligation is solidary, or when the nature of the obligation requires the liability to be solidary, or when the law declares the obligation to be solidary. But kapag hindi present tong exceptions na to, the general rule is that the obligation is joint. Okay? Examples of words used for joint obligations: mancum, mancomunada, mancomunadamente, pro rata, proportionately, jointly, conjoint, or kapag nag-sign ang two or more persons at nilagay nila we promise to pay, that is considered a joint obligation. For solidary obligations naman, usually ang ginagamit na words dyan, severally, jointly and or severally, solidaria, insolidum, solidarily, together and or separately, individually and or collectively, juntos o separadamente, or I promise to pay signed by two or more persons, then the obligation is a solidary obligation. Okay? Example of law requiring or declaring an obligation to be solidary in the law on partnership under Article 1824 for injuries sustained by third persons. Yung mga partners po are solidary liable with the partnership under 1822 and 1823. Okay? Example of the nature of obligation requiring solidarity, yung obligation ng two bailies or obligation of two tortfeasors. Okay? Some rules lang in joint obligation, since ang obligation ng bawat isa sa joint obligation is separate from the rest of the debtors, the extinction of the debt of one of the various debtors will not affect the debts of others. And kapag nagkaroon ng delay on the part of only one of the joint debtors, hindi nun maapektuhan yung ibang debtors. And third, the vices, defects of each obligation do not affect the validity of the other credit or debts. And lastly, yung insolvency ng debtor does not increase the liability of his co-debtors, nor does it authorize a creditor to demand anything from his co-creditors. Ano yung common denominator sa apat na rules na to? A common denominator is that the obligation of one debtor is considered distinct and separate from the obligation of his co-debtors. So kapag may vice or defect sa isa, hindi maapektuhan nun yung ibang debtors. Okay? So take note of that. Now we go to solidary obligations. Take note that there are two kinds of solidary obligations. Active, this is the solidarity that exists among creditors, and yung passive solidarity, ito yung solidarity that exists among the debtors. Anong ibig sabihin nito? When we say active solidarity, there is a mutual representation or mutual agency among the various creditors. While on passive solidarity, ibig sabihin nito, there is a mutual guarantee among the various debtors. Okay? Example of active solidarity. A and B are solidary debtors of C, D, and E. Lahat yan solidary creditors. Because in active solidarity, sabi natin, there is a mutual representation or mutual agency, si C alone can enforce the liability of A or B in the obligation. So, kung may gagawin si C, C will be considered as the mutual representative of D and E in representation to A and B. So kung may gagawin si C, that will be considered as valid and binding, okay, in respect to A or B, the solidary debtors. Because C, in active solidarity, C here acts as the mutual representative of D and E. Okay? Ano ang rules sa active solidarity? Take note that lahat ng beneficial acts pwedeng gawin ng solidary creditor, including the making of demand against the debtor. Okay? Any beneficial act may be done by one solidary creditor. Pagdating naman sa mga prejudicial acts, just like novation, condonation, okay, each one of the solidary creditor may not do any prejudicial act. But take note na kapag may ginawang prejudicial act, yung isang solidary creditor, yung prejudicial act na yan is valid and binding as to the debtors. But the solidary creditor who executed a prejudicial act will be liable to his other solidary co-creditors. Okay? Pero yung act na yan will be considered valid and binding as to the debtors. Okay? Example, in case of remission, novation, or confusion, kapag may ginawa, itong mga example ng mga prejudicial acts, kapag may ginawa dyan, yung isang solidary creditor, it shall extinguish the obligation of the debtors. But, sabi ko nga kanina, the creditor who executed any of the acts above shall be liable to his co-creditors for their share in the obligation. Pero yung mga debtors na napatawad na, halimbawa yung kanilang utang, there's already a remission, ma-extinguish na yung kanilang obligation because the creditor who executed the act is considered as the representative of the other creditors. So that will be considered as valid and binding to the debtors. Okay? If one creditor demands, the debtor should pay that creditor who made the demand. I repeat, in active solidarity, if there is one creditor who made a demand on the debtors, the debtor should pay that creditor who made the demand. Because according to the law, payment to the others who did not make the demand is payment to a wrong person. So halimbawa, dun sa example natin, si A, B, and C, solidary creditors, si C lang ang nag-demand, dapat ang bayaran ng mga debtors ay si C. Pero kung walang nag-demand either from A, B, or C, okay, pwedeng bayaran kahit sino sa kanilang tatlo. Pero kung ang nag-demand si C, at ang binayaran mo si A, that is payment to a wrong person because payment should be made to the creditor who made the demand. Okay? In passive solidarity naman, what are the rules in passive solidarity? Ito yung solidarity that exists among the debtors. Ibig sabihin, they are considered as mutual guarantors of each other. Okay? There is a mutual guarantee that exists among the debtors. Take note that the debtor who made the payment has a right to ask for reimbursement plus interest. So kung tatlo kayong debtors, A, B, and C, si A ang nagbayad, A has a right to ask for reimbursement plus interest. Kailan? From the time he made payment until the time he is reimbursed by his co-debtors. But take note that interest shall not be collected if payment is made before due date. Or worse, if the debtor paid or performed the obligation after the obligation has prescribed or becomes illegal, debtor is not entitled to reimbursement and payment of interest. I repeat, if the debtor still performed despite the obligation has prescribed or naging illegal, debtor is not entitled to reimbursement and payment of interest. Okay? So take note of that. Lastly, on passive solidarity, if one of the debtors becomes insolvent, okay, all debtors, including the debtor who paid, are liable for his share. They are proportionately liable for the insolvent's share. Okay? So take note of that rule in passive solidarity. Let's go to divisible and indivisible obligation. I would just like to emphasize here, joint indivisible obligation. Ibig sabihin nito, joint indivisible obligation, the obligation is joint as to the parties but indivisible as to compliance. So yung parties joint, pero yung ipe-perform nila is indivisible. Like, for instance, in this case, Dabi and Patrick, joint sila. Nag-promise sila to give a specific car worth 2.4 million to Albert. So, joint yung obligation because Dabi and Patrick promised to perform jointly, but yung compliance is indivisible kasi ang ibibigay nila sa specific car worth 2.4. Wala tayong magiging problema dito if Dabi and Patrick will perform their obligation or their share in the obligation. But magkakaroon tayo ng problema if one of the debtors fail to perform his obligation or hindi siya magpe-perform ng kanyang obligation. Okay. Ano ang effect ng non-compliance ng isang party? Sabi ng batas, the obligation will be converted into a monetary one for indemnity. Okay? Ibig sabihin, in this particular example, if Patrick, doon sa example natin kanina, if Patrick does not have the money, okay, mako-convert yung obligation of giving a specific car into a monetary one. So yung obligation is converted into a monetary obligation to give 2.4 million to Albert. So si Dabi na ready na mag-comply, magbabayad siya ng kanyang share, pero si Patrick na hindi ready mag-comply or insolvent will remain indebted to Albert for his share of 1.2 million. That is the rule in case of non-compliance in joint indivisible obligation. Okay? Last, on obligations with a penal clause. Ito yung mga obligation which contains an accessory undertaking to pay a previously stipulated indemnity in case of breach of the principal prestation. Okay? Ang rules lang dito na kailangan nating tandaan in obligation with a penal clause, proof of actual damages suffered by the creditor is not necessary in order that the penalty may be enforced. Okay? And second is that take note also that the debtor cannot just pay the penalty instead of performing the obligation. Bakit? This will make the obligation alternative, except when the right has been clearly and expressly granted to the debtor. Okay? But if wala pong nabigay kay debtor, the debtor cannot just pay the penalty. Okay? Instead of performing the obligation. And take note also that if the principal obligation is void, the penal clause will become void. Okay? Because accessory follows the principal. But if the penalty is void, but the principal is valid, the principal obligation remains valid. Okay? Let's go to extinguishment of obligation. There are 6 principal causes of extinguishment, but take note that the enumeration under the Civil Code is not exclusive because there are other modes of extinguishment of obligation na naka-enumerate or nakakalat sa ibang Civil Code provisions. But there are 6 principal. Ito yung pare, cono, melo, payment or performance, condonation or remission of the debt, compensation, novation, merger or confusion of rights, and loss of the thing. Okay? There are other ways on how to extinguish an obligation. Sabi ko nga, rescission. Meron din yung fulfillment of resolutory condition, prescription, death of the party, happening of unforeseen events, and happening of resolutory period. So there are other causes. So, ibig sabihin, the list in the Civil Code is not exclusive. Okay? I will just discuss some modes of extinguishment. We have payment and performance and condonation. I-discuss ko lang yung iba dito because of our limited time. Okay? Let's start with payment. Ano po ang payment under the law? It is that mode of extinguishing obligations which consists of either delivery of money, or performance in any other manner of an obligation. Example is the rendition of a required service or the required service that is considered as payment under the law. Take note that in order for payment to be valid, the payment must be tendered or given by the proper person. Okay? Under the law, sino ba yung mga proper person? Siya po yung debtor or his authorized representative, or the third person who has been authorized by the parties to make payment, or a third person who has an interest in the fulfillment of the obligation. Yan po ang mga proper person na kino-consider ng batas. Okay? Take note that payment must be tendered or given by these proper persons. Okay? Effect of payment if not from those mentioned. Take note, kapag hindi proper person ang magbabayad or magpe-perform, the creditor can validly refuse the payment or performance. And the refusal, I repeat, of the creditor is valid. But creditor may accept, and if the creditor accepts performance kahit na hindi dun sa mga nabanggit kanina, the obligation will be extinguished even if without the knowledge of the debtor. Okay, question. Kung tinanggap ni creditor yung performance kahit na hindi dun sa mga na-mention na to, okay, ma-extinguish yung obligation. Question dito, ano ang karapatan ng third person na nag-perform or nagbayad ng obligation? Okay, i-differentiate natin. If the performance by the third person or the payment by the third person was made without the knowledge or against the will of the debtor, the third person or the payer can recover from the debtor only insofar as the payment has been beneficial to the debtor. Okay? Mare-recover lang niya kung magkano yung beneficial at wala din po siyang hindi po rin siya magkakaroon ng subrogation rights. Okay? Example, dito, may utang si Dabi kay Albert ng 1 million. Now, or 1,000, sorry. If Patrick, a stranger to the obligation, offers to pay Albert, okay, pwede niyang tanggapin or hindi niya pwedeng tanggapin. Ngayon, pag tinanggap niya yung 1,000 from Patrick, the creditor accepted the payment of 1,000 from Patrick, ma-extinguish yung obligation ni Dabi. Okay? But take note, Patrick can only recover whatever is beneficial to Dabi if payment was made without the knowledge of Dabi or if payment was against the will of Dabi. So, kung dun sa 1,000, nakapagbayad na si Dabi ng 400, ang pupwede lang ma-recover ni Patrick, the stranger or the third person, is 600. Kasi yun lang po yung naging beneficial kay Dabi. Because Dabi had already paid the amount of 400 pesos. Okay? But what if with the knowledge of the debtor? Kung binayaran ni stranger yung utang with the knowledge of the debtor. Okay? In either case, if the payment of 1,000 was made with the knowledge or consent of Dabi or the creditor or the debtor, sorry, Patrick or the stranger or the third person can recover from Dabi the whole 1,000 pesos with all the rights of subrogation, kagaya ng mortgage, yung mga accessory obligations as mortgage, guarantee, or to enforce penalty, if the payment was made with the knowledge of the debtor. Okay? So take note of that. Take note also that the payment should be made to the proper person. Sino po yung mga proper person na yan? Person in whose favor the obligation has been constituted, yung successor in interest, the original creditor, or yung persons authorized to receive payment. I just want to emphasize here na ang tinutukoy po dito na creditor, okay, in whose favor the obligation has been constituted is the creditor at the time the payment is to be made. and not at the time of the constitution of the obligation, because there are certain instances na the creditor assigns, okay, his right to a third person. So at the time of making payment, na-assign na pala. So hindi na siya yung original creditor at the time of the constitution of the obligation, hindi na siya yung creditor at the time of making payment. So take note of that rule. So sabi ng batas, ang proper person at the time of making payment, tignan mo kung sino yung creditor at the time of making payment. Okay? Take note that if payment is made to those persons not mentioned, this will be considered as invalid payment even though the debtor acted in good faith or even by mistake. Kapag hindi po nagbayad dun sa mga proper persons enumerated under the law, kahit na yung payment mo is in good faith or by mistake. Okay? Last, on payment. What if the obligation consists in the payment of money? Okay? Ano ang rule kapag ang obligation consists in the payment of money? The payment should be made in the currency stipulated, or kapag walang naka-stipulate na currency, the currency that is considered as legal tender in the Philippines. Ibig sabihin po ng legal tender, this is the amount. It is that which a debtor may compel a creditor to accept in payment of the debt, whether public or private. Okay? Under our law, only notes and coins issued by the Bangko Sentral are considered legal tender. Okay? Under Section 52 of Republic Act 7653. But as to coins, take note lang yung limitation as to coins, considered lang sila as legal tender if within limits. So kapag ang utang, ang obligation is 1,000, pwede kang magbayad ng piso, 5 peso, or 10 peso coins hanggang 1,000 because up to that amount, considered siya as legal tender. But if 100 pesos, or ang ibabayad mo is 1 centavo, 5 centavo, or 25 centavo coins, up to 100 pesos lang kasi yun lang po ang considered as legal tender. Okay? As to checks, take note na mercantile documents, yung mga promissory notes, bill of exchange, and other mercantile documents, they are not considered as legal tender. Okay? Take note ha, they are not considered as legal tender. Yung mga cheque po natin, checks, whether manager's check, okay, man yan o hindi, they are not considered as legal tender. These are jurisprudence on checks. Sabi ng Supreme Court, reiterating the principle that a check or other mercantile document is not considered as a legal tender. Okay? However, take note that kahit na hindi sila considered as legal tender, the creditor may accept, okay, the promissory note or the mercantile document. But it will produce the effect of payment only. The mercantile document will produce the effect of payment only when they have been encashed or cash, or when through the fault of the creditor they have been impaired. So general rule, hindi po legal tender. Pero po pwedeng tanggapin ni creditor ang mercantile document, but it will not produce the effect of payment unless in two instances, when they have been encashed or cash, or when through the fault of the creditor they have been impaired. Okay? Anong ibig sabihin ng number 2 na fault of the creditor they have been impaired? For instance, in this case, the check was not cash for a long period of time. Sabi ng Supreme Court, payment is deemed effected and the obligation for which the check was given as a conditional payment is treated discharged if a period of 10 years or more has elapsed from the date indicated on the check until the date of encashment or presentment for payment. So kapag daw nag-fail yung creditor na i-encash yung check within a reasonable period of time, in this case, for more than 10 years, not only results in the check becoming stale, but also in the obligation to pay being deemed fulfilled by operation of law. Ibig sabihin na impair yung check through the fault of the creditor dahil sa katagalan ng pag-encash through the fault ng creditor. So sabi ng Supreme Court, when through the fault of the creditor, considered na as paid yung obligation if through the fault of the creditor na impair yung check. Okay? Or yung validity nung cheque. Okay? Now we go to special form of payment. We have Dacion and pago. Take note lang that Dacion and pago, it's that mode of extinguishing an obligation whereby the debtor alienates in favor of the creditor property for the satisfaction of monetary debt. An example of Dacion and pago is the alienation of land and building in satisfaction of unremitted SSS contributions. This is a decided case. Pinangbayad ng unremitted SSS contributions ng company yung land and building, okay, in favor of SSS. Take note, sabi ng Supreme Court, in Dacion and pago, there must be a transfer of ownership in favor of the creditor. Because if there is no transfer of ownership, kung ang nalipat lang is possession of the thing, that is merely given to the creditor, then that is merely a security given to the creditor. So take note, para magkaroon ng valid Dacion and pago, there must be a transfer of ownership of the thing in favor of the creditor. Okay? Now we go to remission or condonation of the debt. When we say remission or condonation of the debt, this is the renunciation on the part of the creditor of the enforcement of the obligation, which will have the effect of extinguishment of the obligation, either its entirety or in that part or aspect of the same to which the remission refers. Okay? Ano po ang requisites ng valid condonation? Meron po tayong 5 para ma-consider natin na yung condonation ay valid. Una, gratuitous, free of charge, walang kapalit na binigay. Kasi kapag meron pong kapalit na binigay, mag-iiba po yung nature ng transaction. Hindi na po yan mako-consider na condonation. Pwede na yung makonsider na ibang transaction. Just like Dacion and pago, kapag may binigay na kapalit. Lalong-lalo na if there is a transfer of ownership. So first requisite of a valid condonation, it must be gratuitous. And take note also that in order for a valid condonation to exist, dapat yung obligation must be demandable at the time of remission. Wala ka pong pwedeng matawag na valid condonation if the obligation is not yet demandable at the time of remission. Anong reason nito? If you're going to read Article 6 of the Civil Code on waiver of rights, pwede ka lang mag-waive ng iyong right if there is an existing right. So, naturally, kapag wala kang right, wala kang i-waive na right. So, in connection with condonation, pwede ka lang mag-condonation ng obligation if demandable na yung obligation. Kung hindi pa demandable, wala ka pang pwedeng i-waive na right. Okay? And take note also that condonation should be accepted by the debtor. Dapat tanggapin po yan ni debtor. Question is, paano kung hindi tanggapin? What if the debtor did not accept the condonation? Pwede pa rin po bang ma-extinguish yung obligation? Yes. But not through condonation. But pwedeng prescription. Kapag hindi niya tinanggap at hindi na rin siningil ni creditor, hindi na in-enforce ni creditor yung obligation, pwede pa rin ma-extinguish yung obligation but not through condonation, but through prescription or some other mode of extinguishment. Pero hindi na condonation. Kasi nire-require sa condonation na dapat tanggapin yan ni debtor. And take note also that it must not amount to in officious donation, ang condonation, and if made expressly, it must comply with the requisites of donation. Ibig sabihin, if the condonation was done expressly, kailangan po nating mag-comply sa requisites ng valid donation. So, if what is donated is immovable property, condonation and acceptance must be in a public instrument. But if what is involved is an immovable property, condonation and acceptance must be in writing if the value of the thing exceeds 5,000 pesos. If not in excess of 5,000, condonation and acceptance may be made orally. Okay? Now we go to novation. Take note lang, in novation, it can be done through substitution of the person of the debtor. And pwede natin gawin yan in two instances, in expromission and delegation. Okay? Substitution of the person of the debtor. This can be done through expromission and delegation. In expromission, yung initiative for the substitution of the person of the debtor it does not come from the debtor. Okay, the initiative for the change does not come from the debtor, since it consists of a third person's assumption of the obligation. In fact, dito sa expromission, it may even be made without the knowledge of the debtor. Yan po ang expromission. In delegation naman, the debtor offers another person. Siya yung nagsasabi kay creditor, siya yung nagvo-volunteer ng ibang tao. The initiative comes from the debtor, okay, to perform his or her obligation. So the substitution comes from the debtor. So the third person assumes the obligation. Ang kailangan po sa delegasyon, kailangang mag-consent yung debtor, yung creditor, at yung third person na mag-a-assume ng obligation. Okay? Take note, whether delegation or expromission man yan, the old debtor shall be released from his obligation. Take note ha, whether delegation or expromission, dapat meron pong agreement na yung old debtor shall be released from his obligation. Okay? If the new debtor is insolvent, the old debtor will not be liable, except kung the new debtor is proposed by the old debtor and yung kanyang insolvency is known to the old debtor or is a public knowledge. I repeat, mare-revive yung action against the old debtor if the new debtor is proposed by the old debtor and his or her insolvency, the insolvency of the new debtor is known to the old debtor or is a public knowledge. The creditor's action against the old debtor will be revived. Okay? So take note of that rule. Okay? So for contracts part, I will just discuss on the basic concepts and characteristics of contract, and then we will go to some rules on consent, forms, and then reformation, and then interpretation of contracts. Okay? We start. Contract is defined as a meeting of minds between two persons whereby one binds itself with respect to the other to give something or to render some service. Take note lang guys na there are instances na hindi po required na dalawang tao para mabuo ang isang kontrata. Because there are what we call auto contracts whereby a single person may create a contract by himself provided he represents distinct interests. So kahit iisang tao, physical, iisang tao can create or can enter into a contract. Ang requirement lang dyan, he must represent distinct interests. example of an auto contract or this single person creating a contract by himself is under 1890, or an agent who was authorized to borrow money, pwede siya yung maging lender at the current rate of interest. Okay? So that is an example of auto contract. Another example, although this is a prohibited contract, a void contract, for those guardians, executors, or administrators cannot acquire by purchase property of persons under their guardianship. This is a prohibited contract, but this is an example of an auto contract whereby a single person can create a contract by himself. So take note lang, again, I repeat na hindi required or hindi nag-a-apply na kailangan two persons palagi. Because there are instances, sabi ko nga, that a single person can create or may create a contract by himself. Okay? And take note also that not all agreements can be considered as contract. Okay? Under 1157, an agreement, in order to be considered as a contract, the agreement must be a source of obligation. Okay? If the agreement is not a source of obligation, that is merely considered as an agreement. Example, let's say A and B agreed that the best chicken joy is the chicken joy of McDo. Okay? So nagkaroon lang sila ng agreement, but there is no obligation arising from that agreement. That is not considered as a contract. In other words, para ma-consider po natin na contract yung agreement dapat ay source of obligation. If there is no obligation arising from that agreement, then that agreement cannot be considered as a contract. Okay? Characteristics of contract, we have obligatory, force of contracts, autonomy of contracts, mutuality of contracts, and relativity of contracts. When we say autonomy of contracts, ibig sabihin nito, the parties may establish yung stipulations, clauses, terms, and conditions that they may deem convenient. Ang exception lang dito, dapat they are not contrary to law, morality, good customs, public order, or public policy. Okay? Examples of void stipulations. Okay? In this case of De Los Reyes versus Alojado, sabi ng Korte Suprema, yung agreement na yung services shall be free. Okay? Domestic services are always to be remunerated, and no agreement may subsist in law in which it is stipulated or agreed upon that any domestic service shall be absolutely gratuitous. Bawal po yan, sabi ng Supreme Court, unless it is admitted that slavery may be established in this country. So sabi ng Korte Suprema, this is an example of a void agreement or stipulation. Another example of void stipulation is in this case of Sweet Lines versus Teves. Nakalagay dun sa ticket yung mga conditions ng company, ng shipping company. Okay? One of the condition is condition number 14. Nakalagay dito, it is hereby agreed and understood that any and all actions arising out of the conditions and provisions of this ticket, ipa-file lang daw po sa mga competent courts in Cebu City. Sabi ng Korte Suprema, this condition number 14 is contrary to public policy. Okay, bakit? It will cause inconvenience to the parties because the philosophy underlying the provisions on transfer of venue of actions is the convenience of the plaintiff as well as his witnesses and to promote the ends of justice. So kung bawal kang mag-file outside of Cebu City, you would incur expenses to prosecute a claim, okay? Para lang makapag-file ka dun sa Cebu, sabi ng Supreme Court, yung plaintiff would probably decide not to file the action at all. Hence, the condition number 14 na naka-print dun sa ticket will thus defeat instead of enhance the ends of justice. This is subversive of public policy or contrary to public policy on transfer of venue of actions. Okay? Now we go to mutuality of contracts. Anong ibig sabihin ng mutuality of contracts? Under 1308, it states that contracts must bind both the contracting parties and its validity or compliance cannot be left to the will of one of them. Okay? This mutuality of contracts is premised on two settled principles. That the obligation arising from contract has the force of law between the parties. That's the first one. And that the second one, there must be mutuality between the parties based on their essential equality. Okay? This also means that any change in a contract must be made with the consent of the contracting parties and must be mutually agreed upon by both of the parties. Otherwise, wala yung binding effect. Okay? I'm going to illustrate this concept of mutuality by discussing a case. In this case of Security Bank versus Spouses Mercado. Okay? Involving interest. Ang nangyari dito, si Security Bank, nag-grant siya ng credit line sa mag-asawang Mercado in the amount of 1 million. Okay? Doon sa credit line agreement, may nakalagay na stipulation. Ito yung mga nakalagay na stipulation. Sabi ng pinirmahan nila, nung mag-asawang Mercado, I hereby agree to pay Security Bank on the basis of its prevailing monthly rate. Okay? And nakalagay din na stipulation, I hereby give my continuing consent without need of additional confirmation to the interest stipulated as computed by SBC. Sabi ng Korte Suprema, this is against the mutuality, the principle of mutuality of contracts because the authority to change the interest rate was given only to Security Bank without the need of the written assent of the spouses Mercado. So sila lang yung nagdidikta. One party, Security Bank lang yung nagdidikta ng interest rate. Second, sabi ng Supreme Court, the interest rate to be imposed is determined solely by Security Bank for lack of stated valid reference rate. So sabi ng Korte Suprema, this is a violation of the principle of mutuality of contracts because mutuality of contracts, both of the parties, dapat meron silang say, meron silang consent as to the change in the contract or any change in the contract must be made with the consent of the contracting parties and must be mutually agreed upon by both of the parties. Okay? Another principle in relation to mutuality of contract is what we call contract of adhesion. Ang tanong dito usually, ang mga contract of adhesion ba is a violation of the principle of mutuality of contracts? Okay? Kasi ano ba ang mga contract of adhesion? Ito po yung mga contract na ready-made na. Ibig sabihin, either one party prepares the stipulation in the contract while the other party merely affixes his signature or his adhesion to the contract. Kaya siya tinatawag na contract of adhesion. Kasi ready-made na yung kontrata, yung kabilang party, ang gagawin na lang niya is to sign or affix his signature to the contract. Okay? Example, ito, in air bill, JRS Express to nung nagpadala ako ng package. So here, the conditions set in this air bill prepared na ng isang party ng JRS Express. Okay? Ano ang rule in contract of adhesion? Ano ang pronouncement dito ng Supreme Court? They are not invalid. Take note they are not considered invalid because they are not entirely prohibited. In fact, sabi ng Korte Suprema dito, yung kabilang party who merely affixes his or her signature is in reality free to reject the contract or the stipulation in entirely, or kung tatanggapin naman niya, gusto naman niya lahat, he can give his consent. So actually, meron siyang choice whether to reject yung kabuuan or to adhere to the whole of the contract, to the whole contract. Okay? But take note lang that because the contract is prepared by one party, if there is any ambiguity in the contract of adhesion, the ambiguities in the contract must be interpreted against the party that prepared the contract. So kung may mga vague provisions or may mga ambiguities in the contract, interpret mo yung mga vague provisions against the party who prepared the contract. Okay? Now we go to relativity of contracts. Ang ibig sabihin lang ng relativity of contracts, only the parties assigns or their assigns and heirs have the rights and obligations under the contract. If you are not a party, you are not the assign or you are not the heir of the parties to the contract, wala kang right and obligation arising from the contract. Okay? Example, in this case of Uy versus Court of Appeals, nagparesin ng contract of sale yung NHA, the National Housing Authority, nag-ask siya ng rescission because hindi na-satisfy yung motive, hindi na-satisfy yung purpose ng NHA, bakit niya binili yung lupa. Kasi ang involved dito is a contract of sale involving parcels of land. Bumili kasi yung NHA ng 8 parcels of land para i-develop niya na housing project. Ngayon, hindi pala suitable yung parcels of land na yan sa pag-develop ng housing project. So nag-ask ng rescission yung NHA. Ang ginawa ng mga agents no nagbenta ng lupa, nag-claim sila ng damages against NHA. Ang sabi ng Supreme Court dito, yung mga agents, sina Uy and Rojas, who are agents, okay, are not considered real parties in interest because they are not parties to the contract of sale between the principals or the owners of the land and the National Housing Authority. They are merely agents of the owners of land. Okay? In fact, sabi ng Supreme Court, there was no proof offered that they are the assignees of their principal or walang proof offered that they are the heirs of the principal. So sabi ng Korte Suprema, since wala silang, hindi sila heir, hindi sila assigns, or hindi sila yung party to the contract, then they are not considered as the real parties in interest. Okay? Exceptions to the relativity of contracts, may certain exceptions tayo. We have 5 exceptions. Stipulation for atruwi, for those contracts creating real right. Creditors are protected in cases of contracts intended to defraud them and any third person who induces another to violate his contract. And in some cases, yung action directa, this can be considered as an exception to the principle of relativity. I'll discuss number 4, okay? This is what we call tort interference. Ibig sabihin nito, a third person or a stranger to a contract who induces another to violate his contract shall be liable for damages to the other contracting party. Okay? In order for tort interference to exist, kailangan po ng requisites na to. Okay? Kailangan there must be a valid contract, existence of a valid contract, and there must be a knowledge on the part of the third person of the existence of that contract. And take note that yung interference ng third person or ng stranger must be without legal justification or excuse. Okay? In order to illustrate this third requisite, tignan natin tong case na to. Okay? In the case of Rubio versus Court of Appeals. Sabi ng Supreme Court dito, when an unpaid seller informs a prospective buyer that he has not yet been paid by the prospective vendor for the shares of stock na binenta niya, this is not considered tort interference. Kasi wala pong illegal interference on the part of the unpaid seller. Kasi yung pag-i-inform niya kay prospective buyer na hindi pa siya nababayaran is valid. Sabi ng Supreme Court, we fail to see any reason why the petitioner should be accused of unlawful interference in maintaining his stand regarding the sale of shares of stock. Kasi mayroon pang hindi nababayaran sa kanya na obligation. Yung prospective vendor. Okay? So sabi ng Supreme Court, walang tort interference kasi hindi na-satisfy yung third requirement that the interference of the third person should be without legal justification or excuse. Now we go to essential elements of contract. Take note, tatlo yung essential elements of a contract under the Civil Code: consent, object, and cause of the obligation which is established. Okay? As to consent, take note lang, as to minority, if a minor enters into a contract, the contract will be considered voidable. Okay? But the minor is given 4 years from the attainment of the age of majority to annul the contract. However, upon reaching the age of majority, he may ratify the contract. Can I repeat? If a minor enters into a contract, okay, the contract will be considered voidable. Pero meron siyang 4 na taon from attainment of the age of majority to annul the contract, except when the minor is guilty of active misrepresentation. Sabi ng Supreme Court, if the minor already passed the age of majority and adolescence in such a way that they could misrepresent and actually did misrepresent themselves as having reached the age of majority, ibig sabihin, nagpanggap sila na sila ay adults na. Sabi ng Korte Suprema, they cannot annul the contract on the ground of minority because of estoppel. Okay? So this is an exception to the rule. Okay? If the minor is guilty of active misrepresentation. Now, as to cause, tignan lang natin as to cause. Cause is the essential reason which moves the contracting parties to enter into a contract. This is the why of the contract. Example, I bought a gun from a store worth 50,000. Yung cost ko for the buyer, bakit ko binili, is the gun. That is the cost of the contract for the buyer. For the seller, yung cost niya why he entered into the contract is the money. Okay? Take note lang that the motive of a party into entering into the contract does not affect the contract, except when the motive of the party predetermines the cause. Ibig sabihin, if the motive predetermines the cause, the motive may be regarded as the cause of the contract. Okay? So when the motive was not realized, it may negate the existence of a cause which will make the contract inexistent. So kung yung motibo daw ng contracting party predetermines the cause, okay, at hindi nga na-realize yung motive na yan, po pwedeng makonsider yung contract as inexistent. Example, in a contract of sale, gaya nung binanggit ko kanina yung case ng UI versus NHA, ito yung case ng ito yung case ng mga authorized agents ng lupa. Binili ng NHA yung lupa, yung parcels of land involved in this case para pagtayuan nga ng housing project. Ngayon, ang sabi ng DNR, hindi pala suitable yon for housing project. So nag-ask ng rescission yung NHA. Sabi ng Supreme Court dito, yung motive of NHA for the acquisition of the land is to use said lands for housing. It predetermined the cost of the contract actually. Because it was not realized, yung motive na yan, kasi nga na-declare na hindi suitable for housing project, it negated the existence of the cost which will make the contract inexistent. Okay? So take note of that rule as to motive and cause of a contract. We go to forms of contract. General rule, contract shall be obligatory in whatever form they may have been entered into, provided present lahat ng requisites. But take note that this rule applies only to consensual contracts because in formal contracts, may mga certain solemnities or formalities na sinusunod tayo in addition to the consent, subject matter, and cause for the validity of the contract. Just like in the case of donation of real property, nire-require po ng batas that it must be made in a public instrument. Okay? As to real contracts naman, in addition to consent, subject matter, and cause, it require delivery. Okay? Because in real contracts, kailangan po ng delivery. Okay? As to the parties. As to forms of contracts, they shall be obligatory in whatever form they may have been entered into, provided yung essential requisites for their validity are present. But take note that this rule, this general rule, applies only to consensual contracts. Okay? Because in formal contracts and real contracts, may mga iba pa tayong kailangang sundin. Just like in formal contracts, may mga formalities tayo na kailangang sundin for the validity of the contract. Just like in donation of real property, which requires a public instrument for the donation to be valid. Okay? And in real contracts, aside from the element of consent, object, and cause, kailangan po ng delivery. Okay? Take note of that. Now, there are exceptions to the form that the law may require a form for the reason of validity, for enforceability of the contract, and for sometimes for convenience of the parties. Okay? For validity, examples of these contracts, ito yung donation of real property, donation of personal property, in partnership, when there is an immovable contributed to the partnership, it is required that a public instrument be executed. And in case of a sale of land through an agent, the authority of the agent must be in writing, otherwise the sale is void. So in these examples, there are certain formalities na nire-require para maging valid yung contract. Okay? If we don't follow the form required, then the contract will be considered void. Now, as to enforceability, eto naman, there are certain agreements na kailangang nakasulat so that they may be enforced. Just like those covered under the statute of frauds. Example, an agreement that by its term is not to be performed within a year from the making thereof. So para pa-enforce natin yung agreement na yan, kailangan nakasulat. Or it must be in a note or memorandum. So for the enforceability of the contract, it must be in writing for it to be enforced. Okay? Another example of cases covered by statute of frauds, a special promise to answer for the death, default, or miscarriage of another. So it must be in writing or in note or memorandum. And under 1956 of the Civil Code, in order for the interest to be enforceable, it must be expressly stipulated in writing. Okay? Now we go to reformation of instruments. Ang question dito is, if the contract is written, may written form tayo, but the written form of the contract does not reflect the true intention of the parties. Okay? Ano ang remedyong gagawin natin? Sabi ng batas, we resort to reformation of the instrument. Okay? Reformation is a remedy by which a written instrument is amended or rectified in order to conform to the real agreement or intention of the parties. Bakit? By reason of mistake, nagkaroon ng pagkakamali because of there's a mistake, fraud, inequitable conduct, or accident, or the instrument fails to express such agreement or intention of the parties. So ang remedyo natin dito is reformation of the instrument. Take note lang, in reformation, kailangan po agreement of the parties. Because if there's no agreement of the parties, hindi sila nag-agree as to the object. For instance, hindi ka po pwedeng mag-reform. Ang remedyo mo is annulment of the contract because the contract will be voidable. In other words, in reformation, the parties must already agree. Nag-consent na talaga sila, meron ka ng perfected contract, but the written instrument did not reflect their true intention. Okay? Requisites of reformation, meeting of the minds between the two parties. The true agreement or intention of the parties was not reflected in the written instrument because of mistake, fraud, or inequitable conduct or accident. Okay? However, in one case, this is decided by Justice Leonen, okay, a 2018 case. He mentioned that reformation of an instrument may be allowed if subsequent and contemporaneous acts of the parties show that their true intention was not accurately reflected in the written instrument. In order to illustrate this, let's discuss the case of Tuscany versus Multi-Realty Development. Anong nangyari dito? Okay. So si Multi-Realty, meron siyang Makati Tuscany condominium, a 26-story building located in Makati. Merong total 160 units with 156 units from second floor up to the 25th floor and 4 penthouse units on the 26th floor. Okay? Meron pong 106 parking slots, okay, allocated as common areas. Ngayon, nung na-create yung Makati Tuscany Condominium Corporation, yung Matusco, to hold title over and manage Makati Tuscany's common areas, ang sabi ni Multi-Realty, nung na-execute nila yung master deed tsaka yung transfer deed, nagkamali sila na hindi nila na-reflect na pagmamay-ari nila yung 98 parking lots over the 106. Kasi merong 106 parking slots designated in the master deed as common areas. Pero hindi daw nila nalagay na yung 98 dun sa 106 pagmamay-ari ng Multi-Realty. So ngayon, nag-ask si Multi-Realty for the reformation of the instrument kasi hindi daw na-reflect na pagmamay-ari nila yung 98. Kasi yung 8 lang daw out of the 106 were actually intended to be guest parking slots. And it retained ownership over the remaining 98 parking slots. Okay. Anong sabi ng Supreme Court dito? Pwede bang mag-reform? Pwede bang mag-grant yung reformation? Yes. Okay? Because if we are going to determine yung contemporaneous and subsequent acts ng parties, masasabi natin na yung dun sa master deed tsaka yung deed of transfer, hindi talaga na-reflect yung true intention. Because first, sabi ng Supreme Court, in the color-coded floor plans for the ground floor, upper basement, and lower basement, only 8 guest parking slots were indicated as part of the common areas. So, talagang yung 98, pagmamay-ari talaga ni Multi-Realty. Okay? And acting under the honest belief that it continued to own the 98 parking slots, nagbenta pa nga actually si Multi-Realty ng 26 units or 28 parking slots sa mga Makati Tuscany unit owners without complaint from the respondent or from the petitioner, si Makati Tuscany. Okay? So sabi ng Supreme Court, parang ina-admit mo yung ownership ni Multi-Realty over these 98 parking slots. Okay? And lastly, yung Board of Directors ni Makati Tuscany made repeated offers to Multi-Realty to purchase the parking slots, signifying na nire-recognize ni Makati Tuscany yung ownership niya sa 98 disputed parking slots. So sabi ng Supreme Court, if you're going to determine the totality of the evidence, yung subsequent and contemporaneous acts ng parties, kailangan nating i-grant dito or i-grant natin dito yung reformation ng instrument because the parties never meant to include the 98 parking slots as common areas to be transferred to petitioner Makati Tuscany. Okay? Now we go to interpretation of contracts. Ano ang rule as to interpretation of contracts? First rule, literal meaning of the stipulations shall control. However, if the words in the contract appear to be contrary to the intention of the parties, yung intention nila shall prevail over the words. Paano daw natin matitignan yung intention of the contracting parties? Tignan natin yung contemporaneous and subsequent acts nila, okay, in order to determine the intention of the parties. Okay? Take note of the doctrine of complementary contracts construed together in interpretation of contracts. Okay? This means that when there are various stipulations of a contract, the various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Ibig sabihin, kapag may accessory contract involved with the principal contract, interpret mo yung stipulations ng accessory contract. You must read the provisions of the accessory contract in its entirety together with the principal contract. This is the doctrine of complementary contracts construed together doctrine. This finds support in the principle that the surety contract is a mere accessory contract. So since yung accessory contract mo is merely an accessory, it must be interpreted with its principal contract, which is the loan agreement. So kapag ini-interpret daw yung accessory contract, yung stipulations ng accessory contract, interpret mo siya in relation to the stipulations in the principal contract. Okay? Other rules in contract interpretation, nabanggit ko na to kanina. If there is ambiguity in contracts of adhesion, the ambiguity should be interpreted against the party who prepared the contract. If there are obscure words or stipulation in a contract, interpret the obscure words against the party who prepared the contract. And take note also that in the interpretation of the contract, we must take into consideration the usage of the words used and the custom of the place. Okay? So, that's all for interpretation of contracts, and that's all for oblicon. Okay, thank you for watching for the short lecture in obligations and contract. Okay, apologies for not discussing all of the topics because of our limited time. So, tinignan ko lang yung mga diniscuss po lang natin, in-include lang po natin yung mga topics, okay, na pwede nating ma-discuss because yung ang limited time natin. Okay? However, I'd like to thank all of you for watching and for listening for sa lecture natin. Maraming salamat po, and to all students, bar reviewees, okay, bar candidates, mag-enroll na po kayo sa Villasis Law Center. Dito po sa Villasis Law Center, napakagagaling po ng mga reviewers natin, yung ating mga lecturers. So kung wala pa po kayo napipili na review center for the upcoming 2021 bar examination, dito na po kayo sa Villasis Law Center. Okay? Very convenient, anytime, anywhere. Pwede nyo ma-access ang mga recording ng videos, ng mga lectures. So pwede kayong mag-review kahit nasaan man kayo. Okay? Pwede nyo ma-access ang mga recordings. So again, thank you for the opportunity, Villasis Law Center, and thank you very much, all of you guys, for listening and for watching. Okay? Thank you.
must sign the verification. General rule, the party must sign the verification. Certification is from shopping, the party must sign. The certification is from shopping. That is the rule. Okay? Who must sign the verification? General rule, the party must sign the verification. Certification is from shopping, the party must sign. The certification is from shopping. That is the rule. Okay?